everyone. I'm Terry Modishead. I'm the Executive Director of the Centre for Legal Innovation at the College of Law, and absolutely delighted to welcome you back to our AI for Legal series, and even more delighted to welcome Professor Julian Webb from the University of Melbourne Law School. Julian, wonderful to have you with us today, and hi.
Hi to you too, Terry, and thank you so much for the invitation.
Absolute pleasure. This is a big topic, lots to discuss, but an important topic, incredibly important in this AI discussion, this whole focus on ethics in legal practice. So I know, Julian, that you're going to jump in and tell us all about this. Really looking forward to it. I'm going to jump off screen and put myself on mute, which is always a good idea, and hand over to you, and I'll see you towards the end. Thank you very much, and thank you everyone for being here.
I look forward to it, Terry, and thank you. And thank you, everyone, for such a, what I gather is quite a wonderful international audience today. Could I just start? I'd like to begin by acknowledging the traditional owners of the unceded lands on which we in Australia at least live and work, and pay my respects to elders past, present, and emerging. I'm like Terry. I think this is an incredibly exciting and current topic, and I guess you're here because I hope to some extent you do too. There may be also, I think, perhaps a slight unintended irony, at least unintended on Terry's part, when she suggested the subtitle, "What You Need to Know Now," because I think that's one heck of a question, and quite a hard question given the state of regulation and the pace of change. So maybe I'm setting you up not to have too great an expectation in having all the answers to that one by the end of the session, because I think there are some points in this where it's very hard to say with any certainty what the answers are going to be. And that's part of what makes this such an interesting topic, I guess. Just as a quick outline of what I'm going to try and cover off in this session. Very briefly, we're going to do a little bit of background and context on legal AI. Just as a prompt and reminder, I know a lot of this territory has been covered in other seminars, and I direct you to the recordings of some of the other seminars that the Centre for Legal Innovation has put together around this series. The meat of what we're going to talk about today is really under that second heading there, AI and legal ethics, and looking at what the lawyer's responsibilities are in terms particularly of what I would see as three core duties, and even this may not cover everything, but competence, care and skill, confidentiality and privilege, and the duty to supervise. And again, internationally, we may have different ways of framing these things, but I think these probably all exist in some form or another for most of our systems. And I'll try and say a few quick conclusory words as well. But just to start with a little bit of background, AI in legal practice. What we're looking at here, of course, when we talk about AI, I think AI in some ways is a really unhelpful term because it hides a lot of things under its particular bushel. It's a cover for quite a range of different technologies, including old school hand-coded expert systems, which are the least problematic for our purposes, machine learning, which has been the main game in town for a while now in terms of a lot of process support AI technologies that are out there. And increasingly we're seeing large language models and large generative AI models coming into the scene. And we all know generative AI and ChatGPT seems to be, and again, question either where the action is or where the hype is, or a bit of both. So I'm going to concentrate on that aspect of AI ethics and legal practice quite substantively. As a matter of AI ethics per se, you may all be to some extent familiar with what we see as the base problems when we're talking about AI in any context, which is that root problem of understanding what's under the hood, what technologists would refer to as the black box problem, because at the center of any AI is the fact that we know it reasons, but we don't always know how it reasons. But one thing is reasonably sure is that quite often it's making connections and correlations that are not self-evidently obvious to us as human beings watching the machine from the outside. There's a big conversation in AI ethics and AI techniques around the development of explainable AI and a recognition, and we see this in legislation like the European AI Act, that we need to be talking about FAT standards, fairness, accuracy, and transparency standards, or accessibility and accuracy standards when we're talking about AI. These issues do have some relevance to us here today. Okay, they're a continuing concern, not just for AI ethics, but also for our conversation around how we manage these technologies in a legal practice environment. And I should perhaps caveat, I'm coming at this from the perspective of an academic lawyer, and so a lot of my answers are shaped by what I know and understand from that basis. I'm not a legal professional, regulation and compliance practitioner as such, so I bring that particular lens to the conversation. Now, a few years ago, with some colleagues at Melbourne University, I was involved in a study that was called RALAT, the Regulation of Automated Legal Advice Tools. And we did a bit of a survey of what was out there at the time and tried to come up with a kind of typology or coding quality, crude quality coding mechanism for looking at advanced digital tools in the legal space. And in essence, what we came up with was this particular model, starting with expert systems at the low end, leading up to the possibility of combining data-driven models with some form of causal reasoning, logic programming technology at the top end to give us potentially hugely powerful reasoning machines, albeit still, artificially reasoning rather than human reasoning. This typology is quite useful to us because one thing it points to is that there's a bit of a continuum going on in this space between systems at the, as you like, the one robot end, the low end of the scale, which have a very low level of autonomy. They're highly dependent on human coding and consequently also have a high level of explainability, through to the other end of the scale, where we might certainly currently are more likely to have a high level of machine autonomy, but a low level of explainability. And I think, as I said, the one caveat to that is where we start moving into high levels of perhaps explainable AI, though that's still very much at the sharp end of where the technology is going. So most of what we're looking at is technology that's working around and looking for patterns in data. We're looking at correlation, not necessarily causation in the way that we would want to understand it, and consequently human training to improve fit and generalization through these technologies is extremely important. Large generative AIs are game changers from the earlier generations of large language models in some respects, and raise important, though not, I think, unique issues in respect of things like copyright and privacy in terms of their training data. And also more specifically, they do further problematize these questions of around trustworthy AI and the regulation of content. And the reason why they are problematic in that area, and why they're also in a way game changers, is precisely because these tools have an ability that we haven't seen in earlier models, which is the ability to emulate human level communication and to some extent con us into think we're talking to a sentient being on the other side of the screen. This correlation causation problem is important to us because pattern matching in language, of course, is not causal reasoning. And we're going to see some examples of where lawyers have already got themselves in serious trouble in failing to make that distinction. Unsurprisingly, we are in territory where AI is raising some really important new questions for legal professional regulation, or at least raising old questions in new ways. In a moment of startling prescience, moving on to my next topic, AI and legal ethics proper. The Law Society of New South Wales in 2017 made the observation that artificial intelligence raises regulatory and ethical issues that require investigation and guidance for solicitors. Yep, I'd agree with that one. Have we got it? Less sure. Let's see why. So let's follow this story through with a number of our key duties as lawyers. And we're going to start with competence. This in many ways, I think, is the most obvious starting point. As lawyers, we obviously have a duty of competence towards our clients, and technology potentially changes the way in which we achieve that duty, but also may extend aspects of that duty to the ways in which we engage with the technology itself. And what we see internationally, or beginning to see internationally, is something of a divergence of regulatory approaches between those systems of lawyer regulation that require quite detailed prescriptive rules and guidance, and those that are much more high levels principles based. And so we could look, for example, at the differences between the US American Bar Association model rules and the kind of rules and standards that we're using here in Australia. As an example of this, under Rule 1.1, Comment 8 of the US model rules, there is a formal expectation that lawyers develop technological competency. And what this seems to translate to is primarily an obligation to find out and understand what the technology you're using can do and what it can't do. There may be a qualified obligation to keep up to date, and we're starting to see this in some of the guidance notes and formal opinions that are being issued across different states in the US. The majority of US states have adopted Comment 8 in some form, so it's pretty widespread, and we are seeing a small number of cases coming through asserting breach of that competency. So it is a real thing. Here in Australia, under the Solicitors' Conduct Rules, there is a general requirement that we exercise competence, care and skill. And again, I think it's no great stretch to suggest that if you're using technology, that duty of competence is implied into the use of your technology. In other words, there is an obligation to find out and understand what your tech can do. Is there an obligation to keep up to date under our norms or under the norms of other systems? I think that's still a very open question. I'm going to come back to it probably a little bit later. So let's just hold it there as a somewhat open question at the moment. There is also an important link when we're talking about the exercise of competence to the lawyer's duty to exercise independent forensic judgment. And this isn't just an advocacy exercise, though it's highlighted certainly in our rules in that context as well as more generally. The Law Society of Western Australia, in its Future of the Legal Professions report back in 2017, highlighted the importance of lawyers not using technology as a substitute for independent judgment. In other words, don't get conned by the tech, don't get caught out by its perceived or assumed sophistication. The onus is on and remains on you to make that independent judgment about what the law is, what the correct processes and procedures are, what the good business advice is, independent of what the technology tells you. It's a tool, it's not an answer. Seems to be the way that the regulation frames things at the moment. Now, it follows from that, I think, that there are always going to be two linked issues that we need to consider. That is what we need to know about the technology, and also whether there are situations whether using the technology or failing to use it might actually in and of itself constitute professional incompetence. So let's start with, again, with, I think, something that gives us quite a useful tool in thinking about this. And this is quite an old formal opinion from the Californian State Bar from 2010. And they said whenever a lawyer is using technology, and of course they were talking about any kind of digital technology, AI back in 2010 was still a little bit of a glimmer in the eye. We're a little bit ahead of the rush here, so they didn't have AI particularly in mind. But I think these 6 considerations that the Californian Bar came up with as considerations are really quite a useful risk assessment tool when we're thinking about our use of technology. And so they said, always consider, firstly, the level of security attendant to the use of that technology. And I think that's also true of a lot of the AI tools we're looking at. If you're putting confidential information in, that's a risk factor straight away. Secondly, they highlight the legal ramifications to a third party who intercepts, accesses, or exceeds authorized use of that information. So there is a question of limited duties to a third party in that context. The degree of sensitivity of the information, I think it doesn't require much explanation beyond what it says. The possible impact on the client of inadvertent disclosure of privileged or confidential information. And again, this is one I'm going to come back to. The urgency of the situation, I think that's an interesting one. You can see it in some tech contexts if you're talking about the use of, for example, unsecured document storage tools, or if you're sending an email off of a private phone or not using a VPN. You might say there are circumstances where some of those things are more justified risks than others. I think urgency is maybe a harder question around AI as to whether that is a key determinant, but we shall see. And lastly, and by no means least, of course, the client's instructions and circumstances, and including issues like access by others to the client's devices and communications, which again have significant confidentiality and possibly privilege implications. If we apply some of these things to AI specifically, I think what it points to for me is that there are a number of things we really need to pay careful attention to if we're starting to if these tools are going to be available to us and we're starting to use them. Firstly, you need to be aware, particularly if it's not a built-your-own system, what are the use cases and operational parameters of the AI you're using? They don't work for everything, and most cases they will have certain specific parameters that are laid down for use, and stepping outside of those immediately puts you into potentially problematic territory. Some of that information will be available but through terms of service, and as we've seen with OpenAI over the last few months, those terms of service may change substantially and quite rapidly, frequently. And those terms of service may be particularly important around issues like data retention and storage and the privacy of information that you're entering. Cybersecurity questions are always important for us in our domain, particularly if we're using systems that hold confidential information. So part of your search strategy, as you often would be, you are putting in client information, client-specific information, even if generalized to a degree. How is that information held? Is it held? Crucial questions. The other thing, particularly with tools like ChatGPT, is that there is a real science to drafting the prompts, the search, in inverted commas, search terms. There's an old computer programming term, the days when I was learning old school software packages like BASIC and Fortran, GIGO, garbage in, garbage out. And it applies with absolute certainty in this area. If you're not putting together effective prompts, you are not going to get good answers. And there's lots of training out there increasingly about prompt design. Have a look at it if you're planning to use this stuff. Do bear in mind, and I think, again, this is a universal point, not just Australian specific, that the primary basis of our ethical obligations is individual. It means that what we need to know are your individual responsibilities, and this comes out in the US case law and opinions as well, for sure. It's fine to ask your tech people, but you've got to ask your tech people. You've got to know what the parameters are, what the risk levels are, to be able to satisfy meeting your duty of competence. Consider that there may be very different levels of ethical risk with regard to in-house and external tools. And again, this is not a new conversation for us in the technology-assisted practice space, but it is an important consideration. And one should always check for regulatory or in-house guidance on the use of particular tools and whether particularly external tools are permitted for use in your practice. And it's always useful and important to talk to your own tech team if you have one, or to your suppliers if you don't. We do have very recently, literally less than a month ago, the first bit of guidance within our jurisdiction on the use of AI language models. And I think it's an incredibly sensible little piece of guidance, and that's from the New South Wales Bar. And it makes the critical point right up front that GPTs in particular are not reliable in providing accurate legal information. Hopefully this isn't news to us. Their ability to hallucinate, as it's being referred to, is increasingly well known. And some of you may have seen in the news the horrible case to US lawyers who thought they could treat ChatGPT as just a legal information resource, a search engine type of resource, and that all it would do is search for information that was out there, put together a document for the court which contained 5 entirely fictitious precedents, and had to suffer the very significant consequent embarrassment of their error when the court called them up on that one. So we need to understand the tools. We need to be able to verify the accuracy, reliability, and currency of the information that's being generated. And I think the Bar guidance also makes the point about keeping records of what you've done. Keep a record of the prompts that you've used, the choices you've made and why you've made them, and the results that have been generated by the tool. One of the features, if you've used ChatGPT, that you'll see is even if you put in the same or very similar prompts, you're not necessarily going to get the same answer, particularly using the lighter weight public version of ChatGPT rather than the pay-for-use version. So keeping a track of the results generated is also important in that context, I think. And again, it also makes the point I've already made about noting the terms of service. What about guidance for solicitors? At the moment in this jurisdiction, we're not there. I think looking at the UK as well, I haven't seen any particular guidance on the use of GPTs or similar models published there yet. I know the Victorian Legal Services Board in my own jurisdiction is working on this currently, so there is likely to be something, but it is an area where, as I'm afraid is often the case, there is a degree of playing regulatory catch-up given the pace with which the technology is moving on. But if anyone does know of any other guidance that's out there, official guidance from regulators, I'd be really interested to hear about it in the chat. Is the failure to use AI ever incompetent? I'm going to treat that as a rhetorical question, you might be pleased to hear. And I think it's a genuinely hard question again. We need to remember that the standard of competence is somewhat fluid and capable of evolution. The benchmark is the standard expected of the reasonably competent solicitor, lawyer. once the reasonably competent lawyer is using tools, I think, as a matter of standard practice, once some of these tools become ubiquitous, then I think there is a serious yes answer to this question. But I don't think we're anywhere near there yet. Improper use is a different matter. Improper use, I think, does beg the competence question, but failure to use may be in some senses the safer option than using badly, at least for a while yet. Okay, my second topic, confidentiality and privilege. We're kind of, if anything, scaling up. This, I think, is an even harder question, perhaps unsurprisingly. Questions of confidentiality and particularly privilege, we know in all kinds of ways, can be a bit of a minefield. And I think there are a number of key risks here that we need to be aware of. The first is the underlying risk to confidentiality itself. And that is the sense that if clients in particular do things with their information that means that information loses the quality of confidentiality from the outset, then that obviously may have an impact in terms of confidentiality that you might be able to claim over that information, and also any further related privilege claims that may arise. Now, it's a hard question, how much disclosure, because we know in other contexts some disclosure may not damage the quality of confidentiality. Disclosure to an AI, again, we're going to have to look at the terms of use and service. Are there expectations that users to that hold all the information that is disclosed to them confidential? Does the AI itself hold the information confidentiality and not disclose it to other users? What's going on here? But as a rule of thumb, the broader the dissemination or possible dissemination of information that has otherwise the quality of confidentiality may be problematic, because it may destroy that quality of confidentiality ab initio. And if it ain't confidential information, then you cannot claim privilege over it. Once we get into the territory of privilege itself, even if the baseline confidentiality criterion is still satisfied, there may be some difficult questions of express or implied waiver, either by the client or by the lawyer on the client's behalf. And again, there are going to be complex variables. Is the disclosure to a person? Is that going to be accessible by a human being? Could the AI be conceivably an associate or agent or even confidant of the user? If the answer to any of those is yes, then the risk of waiver is correspondingly reduced. Could we as lawyers argue that the waiver is vitiated because the disclosure is inadvertent, as a mistake? Again, there might be hard decisions and hard distinctions that the jurisprudence needs to make between the kind of mistakes that we currently recognize, where something is simply physically disclosed, as it were, by error, i.e. it's included in a bundle where it shouldn't be included. And certainly in our jurisdiction, the courts are getting less tolerant of lawyers having side fights around that sort of question. Versus what we might see around AI disclosures, which is where there is some mistaken belief as to the security or terms of confidentiality on which data is held. Now, is that a reasonable mistaken belief, or is that, again, a lack of attention or lack of competence? Are those distinctions going to become material? To my knowledge, I haven't come across any case law on anything like this at this stage, but it does seem to me it's a potentially moot question. And if we look at OpenAI's current terms of use, you can see why, Houston, we could potentially have a problem here. One thing that's very clear from these terms of use is, firstly, that for a number of AI's tools, and so you've got to make a fairly technical distinction between AI's API content and non-API content, and here's a big clue, non-API content includes ChatGPT, makes a difference, because they say we may use content from services other than our API to help develop and improve our services. In other words, if you put client confidential information into a prompt to get a more accurate response out of the tool, then that is potentially going into the training set. If you don't want your non-API content to be used in that way, you can opt out, but you have to actively, physically opt out. It's not an opt-in model. The other red light for me under term 5 is the opening interesting line. You may be given access to confidential information of OpenAI, its affiliates, and other third parties. Who are the other third parties? Not defined anywhere in the terms of use or anything else I've seen. Are users third parties? Does this mean you might be given access to other people's confidential information? If it's going into the training set on ChatGPT, you probably almost certainly are. Do you know it's confidential? No. So the protections and requirements that you should not disclose confidential information only works if you know it's confidential information or should know it's confidential information. We're in incredibly tricky, dangerous territory, I think, through these terms of use. Here's a little one to test you on. If anyone are interested in having a go at this, you might want to put your answers in onto the chat rather than the Q&A here. I'd be interested to see what you think. So you have a time-poor litigation client who's not particularly confident as a written communicators. They know enough about the technology and have heard enough about ChatGPT to have worked out that it actually writes rather well. So smart idea. Let's get ChatGPT to write an email to you, their lawyer. So they do that, compose an email to you that contains information which you might rightly assume would otherwise be confidential. So assuming that the communication would, but for this mode of drafting, attract privilege, do you think the use of ChatGPT in this case could be sufficient to take that information outside of the protection of client legal privilege? There are some interesting analogies. The Simkin and Barclay Group case is an English High Court decision. It's on use of not particularly secure cloud storage systems. And the court accepted there, in principle, that sharing data to a cloud storage system could be inconsistent with and could constitute, under certain circumstances, a waiver of privilege. So we do have, I think, a broad analogy there. So my last kind of key area, supervision of systems and users. And again, here I'm conscious that normative standards in different jurisdictions apply somewhat differently. Under the Australian Solicitors' Conduct Rules, which apply in some form in most jurisdictions here in Australia, Rule 37 requires solicitors with designated responsibility for a matter to exercise reasonable supervision over solicitors and all other employees engaged in the provision of the legal services for that matter. If you're supervising a team and that team is using AI, I think there's a reasonable argument that can be made by extension to say that the duty to supervise extends to ensuring that the AI is being used appropriately and consistently with its use cases and you know what its capability. I think in a way we're saying here that the obligations on us as lawyers with respect to AI are broadly analogous to those governing outsourcing. It may be remote, but we are certainly formally under an obligation to keep an eye on what's going on at that other end of the organization, even though a lot of the details are actually external to us. So I don't think there is actually a a huge problem in saying that that duty extends to us as lawyers. The scope of that and the implications of that, again, might need some working out. There is an interesting point here, of course, is that the duty to supervise is again framed as an individual duty in the Australian standards. You might look at this rather differently, for example, in a UK context where you have a separate code of conduct for the firm, and there are in that sense firm-wide obligations, and those who are in management responsibilities within a firm have broader obligations. And so you might say actually there might be a collective duty to supervise in those kinds of situations, those kind of regulatory frameworks that we don't formally have under the ASCR here. I thought I'd finish with a couple of points. One is an aside, and this is kind of bringing in my kind of legal regulation, innovation, troublemaking side, if you like. I do think longer term, there's some really interesting questions that AI and other digital tools, sophisticated digital tools, are going to raise for the continuing structure of legal services regulation and ethics. I do think these have the potential to quite radically change the risk environment. How? I think it comes down to these 4 factors in what I would call AI risk assessment. If we have AI tools that are accurate in terms of their coding and learning so that they are reliable in the information they give out, that they have a requisite level of transparency or explainability that enables us as lawyers to see how the tech has come up with the solution it's proposing, or indeed not just us, it could be the courts in some circumstances, seeing how it's come up with its outcomes. If the risk of negative outcomes from reliance on the tech are relatively low, and the consequences of those negative outcomes are also relatively low, then we might say, does that AI need to be managed or utilized within regulated legal practice? Is there a case here for thinking about alternative forms of regulation? We might think about platform regulation, for rolling back unauthorized practice of law norms, for various other measures that might be useful for us to take in a, particularly in an access to justice type of lens. In other words, I think AI does create some really interesting challenges for the information advice distinction on which a lot of current professional regulation currently lies. So it is, in that sense too, not just in terms of thinking about our ethical obligations, but thinking about the nature of lawyering, a bit of a potential game changer here. But cycling back to our ethical obligations. Do we as lawyers have any kind of duty to innovate? A US colleague of mine, Rennie Kanaki Jefferson, has written a piece, a very learned piece in one of the US law journals, arguing that there ought to be a duty on lawyers to innovate, not just in digital sense, but given the access to justice crisis, absolutely there should be. We're not there. We're certainly not there yet in any jurisdiction that I'm aware of, and certainly not in our Australian jurisdictions. But AI isn't going to go away. It is already getting better. We're seeing the development of more applied tools in the generative AI space in particular. Some of you may have seen the announcement by Dentons that they're using or developing a secure ChatGPT of their own at the moment, and we're going to see more and more of these tools either being designed and utilized in-house by the biggest firms or being marketized by OpenAI or other developer affiliates. There's no question about this. So the questions we're talking about today, the issues of ethics, are not going to go away. And at the moment, as I've tried to highlight in the presentation today, there are some significant mind the gap problems in terms of how the rules apply. And I would suggest at this stage, a relative absence of guidance. And I think there is a certain onus on the regulatory authorities to up the ante and give us a little bit more support, please, in dealing with these tools as they come in, acknowledging that that's quite a difficult task at anything other than a level of generality. I think my final point would be to say very quickly, always keep in mind the core context, your duty to act in the best interests of your client. And I think that needs to be applied to the use of technology tools as they would to anything else that we do in the office. I think AI has the potential to bring significant quality and efficiency gains in some areas of work, and we're already exploiting those in the obvious areas like e-discovery, contract drafting, etc., etc. That will continue. The extent to which those efficiency gains are and should be passed on to clients, I think, is another important ethical question for us in our firms as well. So to that extent, I think even if there isn't a formal duty, there should be a commitment to innovation in effective practice, but always assess the risk. And I'm going to stop there. Thank you very much.
And thank you. What a fabulous presentation. We've got a question here which I'm going to pose to you in 1 second, and I've got one for you as well. So if I can, Julian, just pose this first question. How do you think the court will view the use of generative AI reports as expert evidence?
That's
a curly one for you,
such a curly one. Yeah. Oh my goodness. No, I'll be absolutely honest. I haven't turned a lot of attention to that question, partly because it is such a curly one. I think you've got layers of problems there, haven't you? One is, what is the credential of the AI as an expert? Where is it getting its information from? Currently we know a lot of it is from public source, from Wikipedia. You can read Wikipedia if you're using the free version ChatGPT and think, oh, I know where this has come from. So does it have that quality of expertise? That's one issue. Are you using it primarily to polish the writing, or are you using it to generate information? I think if you're using ChatGPT, and I think this applies to a lot of things, you could possibly say the same about boilerplate drafting as well. If you're using it to polish the writing rather than to generate the actual expert content, I don't think you have a problem. Do we run into, I'm going to ask you a question back almost, maybe a rhetorical one. Do we run into a problem of independence?
Yeah, and we'll wait for the response, but there has been a response in also in the Q&A, which is going to the point that you made, Julian, is can you validate the evidence? So it goes to that transparency issue, and I guess it also goes to, what's emerging, I think, in the US, and you may want to comment on as well, which is in some places, some directions that you have to disclose whenever ChatGPT or other generative AI has been used in anything. It's simply a requirement, a blanket requirement now. Doesn't seem to have reached, unless you've seen something to the contrary, the level of a national requirement or for all courts in every state, but certainly some of them. I think New York is the one I saw that come out of.
Yeah, there's been others as well. I can't reel them offhand, but it's there's been a bit of a crescendo movement in that area. So I think courts and regulators internationally are looking at that one. So I think having a general standard of AI disclosure it's a kind of regulatory sensible move, and it's an easy win. So at least then everyone is on notice about what's being used. And I would actually say, probably as a matter of good practice, it's not a bad thing to be doing, whether there's regulation there or not, in terms of putting everyone on notice about what you're doing.
Yeah, absolutely. The other suggestion that's been made here is that you can subpoena the metadata of the evidence in question. But I guess that goes back to that point that you were making earlier as well about that expanded skill set need for lawyers to kind of have almost a forensic understanding or capability around where the data is coming from, right?
Yeah, no, absolutely right. And actually understanding metadata, I think we've got a lot better on that as we've moved increasingly, particularly in litigation, to normalization of electronic information discovery and electronic information data sets. But you remember in the early years, asking lawyers to do stuff with metadata was more often than not just get a glazed look in response.
Absolutely. Yeah, absolutely. I was going to ask you the question, and it's an ethics-based question, but the suggestion has been made in terms of, I'm going to call it very broadly, the professional responsibility aspects of all of this, that you can stretch pretty much what's there now. You can stretch it out far enough, if you like, to cover off, and certainly to cover off things like the US examples that you gave, where it was, to me, it was just not checking the actual information or confirming it yourself before you submitted it. Do you think that's the case? So I just want to drill down on that one a little bit, that we can stretch what's there, or do you think, no, we've actually got some additional elements here that we need to cover specifically?
I think bottom line is, at one level we could stretch what's there, because I don't think there are many risks, any risks that AI is creating that are completely unique. Certainly not unique to not occurring in some way with other forms of digital technologies. And I might be wrong on that one. This is such an evolving area.
Yeah.
So I could easily be proved wrong on that one, but that's my instinct. I think there's a could or should distinction here, because this is such a new area, and the learning curve for practitioners is so high. I think there is a question about whether there are things that we should be doing to support them, regardless of what the rules actually say, which is, I suppose one of my beefs, particularly in the Australian context, is the thinness generally of the commentary that we have to the Australian solicitors' conduct rules. It's actually incredibly thin in a whole lot of areas, and indeed the more difficult and contentious the area, the less commentary in some cases we get on it. And while at one level I understand that, I don't think that necessarily does a service to the profession. Having been a very strong proponent of principles-based regulation, I also keep coming up against these problems, and I keep talking to another colleague in the UK, Richard Moorhead, who's very hot on all of this stuff, and really interesting if you want to have a look at for any of the audience out there who don't know Richard's work, who's a very practice engaged legal ethics scholar, who says all sorts of interesting things. The longer we do this work, the more persuaded we become that rules are actually quite useful.
Yeah, absolutely. And the next question I want to ask you is this. I guess the default in terms of conduct rules more generally, is to go national versus by state. And one can see the pros and cons, obviously, of each approach. And I guess the US has the model rules, and then each state obviously decides whether or not to mandate them or just to recognise them. Do you have a thought about that, whether it makes sense for all of this to remain national, or whether there should be any particular nuances from state to state?
It is such a difficult question, isn't it? There's been quite a consistent pushback against uniformity. We know for the large firms, in one sense, significant variation is a problem because it raises cost of compliance and complexity of compliance across jurisdictions. That's not going to be an issue for a two-person practice in a regional location somewhere at the back end of Victoria or Queensland or wherever else it may be. So different risks and considerations occur. I'm going to stop waffling on this one, haven't I? I tend, I suppose, almost on market principles, to favour uniformity. I think if we, I think it, as much as anything, I think it makes the job for us. I suppose I'd say that because I think it makes the job for us as trainers more complicated if we're having to judge and assess these things on a state-by-state basis. It limits, or it doesn't necessarily limit, but it certainly impacts lawyer mobility and creates challenges for lawyers who want to be mobile, and it does sometimes create challenges on transborder type activities as well. And I think that's been a bigger issue in the US than it has probably ever been here in Australia. So I, on balance, favour uniformity, but I acknowledge the arguments against it, and particularly for some of the smaller jurisdictions where uniformity does also increase the cost of regulation potentially.
I have one final question for you, and it's I guess it's who should have input in terms of thinking about these issues around professional responsibility. And I'm thinking particularly that we have a broad discussion. We have it in Australia with the Responsible AI Network from CSIRO, and obviously others around the whole thing around AI. And then, of course, it seeps down into the various, professions, industries, however one categorises that. With this question of AI and formulating, perhaps understanding better our professional responsibilities, how important is it for us as lawyers, as a legal ecosystem, to be thoughtful, reflective, and to proactively seek input from other disciplines? And I'm thinking particularly STEM here, right?
Yeah.
In terms of ultimately formulating whatever national, state, whatever the ultimate outcome is going to be.
Yeah. I think it's enormously important. And you highlight STEM. I would make a big plea for the humanities as well.
Absolutely.
I follow my good friend and colleague Tim Miller, who in fact has just moved up to a chair at the University of Queensland from Melbourne. We collaborated on the RALAT project together. Tim is a computer scientist who says we absolutely need the social sciences and humanities in this conversation. Not least because there are some of these deeper philosophical questions, and I think there are some philosophical questions that underpin the regulation if we want to go deep enough, and we don't always go deep enough when we're framing professional regulation. In my experience, it's been a very pragmatic exercise in most jurisdictions I've had experience of. But I think sometimes it's useful to go back to first principles, and that should be a cross-disciplinary conversation. None of us know it all. And it was really interesting. We tried to do some work that you'll be aware of about a year, 18 months ago, to do a follow-up on RALAT on broader questions around legal services regulation. It was sort of bad timing. We were all coming out of COVID, and we got a very low response rate. Not really enough to do much with the data at all. The bits of data we had, some of them were quite interesting. But what was particularly interesting, I think, was even within the data we did get, there was a tendency not to see regulation as a big issue, as an important issue in this space. And I find that slightly worrying. And, and it may actually even, we don't know for sure why we didn't get a high non-response rate, but with focus on regulation, if people don't see regulation as an important issue, that in itself may have contributed to the non-response. But I do think we do need to take regulation seriously, because it's only going to get more complex. And of course, it's not just professional regulation. There's a whole interplay. Review of the Privacy Act, got international standards from the GDPR, the AI Act, there's a whole panoply of legislation internationally that is impacting this space, and it all comes together and we can't ignore any of it at the end of the day.
Absolutely. I mean, we can expect regulation and compliance, and as you said earlier, just to be an integral part of risk management now around all of these things, not least of which is our own personal professional obligations as well. Julian, a fantastic conversation. Thank you so much for it. It really is watch this space, isn't it? Because it's evolving before our eyes. So I'm sure we'll be coming back and checking in with you and getting us to update us from time to time as well, and look forward to that very much. So thank you very much, Julian. Really appreciate it.
Been a complete pleasure as always, Terry. Take care, everyone, and thank you.
Thank you. Thanks, everyone, for attending. You will find Julian on LinkedIn and a bunch of other places. Obviously, the contact information is here in front of you, and you'll find the Centre for Legal Innovation in all of those places too. Thanks, everyone, again very much. Bye. See you next time.